I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So yes, it is premised, but if I use the term independence of judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and not use the word judiciary. And then the argument goes back and forth, the same one, he's the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say, use not the word independence, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
Two very brief responses. Your Lordship should give credit when this law was being debated in Parliament. The very point that your Lordship has said was also raised. And they said...
in fact, incidentally, there are two orders of this court, and the learned Attorney General also undertook to place on record the debates
in an earlier hearing, it was pointed out that it is available online.
If that order
I think it's been placed by one of the lawyers. It's available in CMA 8565. One day's debate has been placed.
It's a good 150 pages.
Some parts of it have been placed on the file.
All I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it, I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April and on the 13th of April it gets fixed.
So, Mr. Zaid Ibrahim,
this itself is a vindication of this law.
Can be fixed by the Supreme Court itself. So, if you point out
all the Parliament
to the
is saying,
Court and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues. Sir, how does the Parliament come in?
Order 19 of the Supreme Court rules, Order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay. So it's a question of implementation. So according to you, the rules are already there, they are not implemented.
No,
so if it is incorporated in a statute, it would ensure implementation.
It is not incorporated in the statute.
Zaid Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which will strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr. Zaid Ibrahim,
the main question is,
Mr. Zaid Ibrahim, all that the Parliament has done.
Yeah, door is the question that will determine.
The Constitution, for the time being, does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it all is a door or not. What comes through the door is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has stated. I view it differently. The Parliament, since this court, having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is try to structure the discretion which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
सब्सक्राइब करें और बेल दबाएं ताकि कोई खबर रह न जाए।